for someone trying to succeed in the film industry or any creative space is if you're doing what everyone else is doing, you're doing it wrong.
That quote, Johnny did a number on me, end quote. This testimony is contained in Dr. Cowan's deposition transcript, which is Exhibit Q. It is also contained in Dr. Cowan's medical notes in Exhibit R at Dep 9122 through 23 and is contained in text messages that are Exhibits S and T. Mr. Depp objected to Dr. Cowan's testimony, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the ground that the testimony about the abuse was hearsay. Alan Blaustein. On April 29, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Alan Blaustein, a clinical psychologist who worked with Mr. Depp. Dr. Blaustein testified that in the therapy session, Mr. Depp reported that he had cut himself as a child and burned himself with cigarettes. Dr. Blaustein also testified about the drugs that Mr. Depp was on, as reported to him by Ms. Lloyd. This testimony is contained in Dr. Blaustein's deposition transcript, which is Exhibit U. This information was also contained in emails, which are Exhibits V, W, and X. Mr. Depp objected to Dr. Blaustein's testimony regarding the cutting and burning himself as speculation, and the testimony regarding the drugs Mr. Depp was taking as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on these grounds. Bonnie Jacobs. On May 4th, 2022, the defendant attempted to introduce into evidence the treatment notes of Dr. Bonnie Jacobs, a clinical psychologist who worked with Ms. Heard. The treatment notes show Ms. Heard reporting abuse by Mr. Depp, including sexual violence. The treatment notes are Exhibit Y, and based on the court's ruling, the defendant did not call Bonnie Jacobs as a witness. Mr. Depp objected to Dr. Jacobs' notes as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on those grounds. I have some more. Give me a moment.
As long as you don't just keep turning every page in that book.
No,
I'm not staying for that.
It is not.
Okay.
The UK judgment. On April 29, 2022, Ms. Heard moved to allow evidence and questioning regarding the UK judgment and for admission of the judgment itself, which is Exhibit Z. In support for her motion, Ms. Heard argued that Mr. Depp had opened the door to the admission of the judgment by presenting evidence of damages after the date of the judgment on November 2, 2020. For example, Ms. Heard observed that Mr. Depp had sought damages for losing his role in Pirates of the Caribbean 6, a movie that has not yet been made. Ms. Heard further observed that Mr. Depp testified that the op-ed had caused him and his family irreparable harm, thereby suggesting that his reputational harm had continued to the present. Ms. Heard noted that Mr. Depp's expert designation indicated Michael Spindler relied on Mr. Depp's earnings from 2019 to 2021 when reaching his opinion, which resulted in an amendment to the designation. Ultimately, the court found that Mr. Depp had not opened the door to the admission of the UK judgment and overruled the motion, which the court did again today with Mr. Banya's opinions. Finally, Adam Bercovici. On May 19, 2022, Ms. Heard attempted to call Adam Bercovici, who is an expert in the policing and Los Angeles Police Department policing of domestic violence calls for service. Mr. Bercovici would have testified to his qualifications in the field of policing and LAPD policing of domestic violence calls for service as follows, and further outlined in Ms. Heard's fourth supplemental and rebuttal disclosures dated March 31st, 2022. Mr. Bercovici spent 30 years with the LAPD, retiring in 2012 at the rank of lieutenant. He has extensive experience as a patrol officer, field supervisor, uniformed watch commander, both as Sergeant 2nd and Lieutenant 1, along with multiple assignments as an officer in charge, Lieutenant 2nd of specialized detective units. During his tenure with the LAPD, Mr. Bercovici held numerous positions directly responding to and overseeing subordinate officers' responses to the domestic violence calls for service, including as a patrol officer, supervisor, watch commander, and assistant watch commander. And actually this, Your Honor, is the person who prepared this prepared a longer brief of what he was going to say, is it okay to just submit it rather than hearing me read it all?
Any objection to that? No objection. Okay.
Okay.
That's fine.
And with that, that's...
Okay. You just scared me with the size of that.
No,
just wanted to-
I understand.
Okay. All right, that's fine. If you can get Jamie our copy of it, we'll make sure it becomes
course,
part
sir.
of the record as well, okay?
Thank you.
All right. Do you have any proffers, Mr. Chu, that you need to, at this point?
Not at this time, Your Honor. Thank you.
All right. Then I think there's just a couple things I need from you. Like tomorrow, let me, by the end of the day tomorrow, if I could get clean jury instructions without the cites on them for the ones that have been admitted, and also the verdict forms as well, if that's been worked out, okay?
Your Honor, we sent revised jury instructions to them yesterday morning and a revised verdict form today, so just waiting to get
Okay,
back, but
sure.
we'll coordinate.
All right, thank you. And you're working with Jamie about some exhibits. There's some that were, both sides noted that were in evidence that are not, so I want to make sure everybody gets everything cleared up. You're caught up? Okay, good. All right, just keep that going so we can get that, make sure that's taken care of. As far as time left, Sammy, today, I can give you a rough estimate for two reasons. One, you had some depositions, so make sure you give the breakdowns to Sammy about those. And two, Sammy wasn't here today. He had a mandatory CLE that he had to do, so I just did a rough estimate, and I want to qualify that as a rough estimate. But it looks like the plaintiff has used about 5 hours today, and the defendant used about 1 hour and 15 minutes, is what I have, okay? And again, that's a rough estimate, so don't expect them to be the same, but Sammy's going to get to it this evening and send you an email this evening with the actual accurate times, okay? Anything else?
No, thank you, Your Honor. Thank you.
All right.
No, Your Honor.
Okay.
Thank you.
Have a good evening. We'll see you in the morning.
You too. Thank you.
All right.